Good morning. Welcome to today's Ask a Pro webinar. Today's topic is the CFPB's new debt collection rule and how Regulation F will impact creditors' first-party collections. My name is Sara Costanzo. I'm a shareholder with Weltman, Weinberg & Reese. I've been here approximately 26 years, managing a variety of practice groups over that time, and now focus primarily on client services. I'm active in our legal community, and I do lecture frequently on other topics, including new regulations like this. I am going to make a couple of announcements before we get started, just a few housekeeping things. This is an interactive session, so over to the right of your screen, you should find a box where you can submit questions. You can type them in, and those will be answered throughout the presentation. If there are any questions that we don't get to, we will follow up with you following the presentation to be sure to answer those questions. The webinar is being recorded. At the conclusion of the presentation, a link will be sent to all attendees, and so we ask that you complete a survey at the end of that and share your feedback, which would include any topics that you'd like us to cover in the future. Now a little bit more about our panelists, since I'm just our moderator. Beth, do you want to introduce yourself to the group?
Sure, thank you. Good morning, my name is Beth Cole. I have been with Weltman for a combined total of 12 years. My group is responsible for loading electronic client new business, and we're excited to hear what kind of questions that you have and share some information with you today.
Thanks, Beth. Our next panelist is Jamie Hart. Would you like to introduce yourself, Jamie?
Hi, everyone. Jamie Hart. I am a shareholder in the firm's Cincinnati office. I've been with the firm since March of 2009. My practice is primarily in the consumer and commercial worlds in Kentucky. I do a little bit of work in Ohio, and then I manage our firm's Kentucky, Indiana, and Southwest Ohio litigation groups. And again, like Beth said, very happy to talk to you about this topic today. It's very important for our industry and how things are going to change going forward. So thank you.
Thanks, Jamie. And our final panelist today is David Head. So last but not least, David, do you want to introduce yourself?
Absolutely. Good morning, everyone. My name is David Head. I am also a shareholder here at the firm out of our Cleveland office. I have been here since 2003, so I've been here quite a long time, but not quite as long as Sarah. I've been around the consumer world my entire life here at Weltman, and have recently taken over oversight of our consumer practice, litigation, and collections on the consumer side. So I look forward to today's conversation. Obviously, that impacts us directly, and by that impacts you as well. So we look forward to the conversation today.
Thanks, David. With that, we'll go ahead and segue into the actual presentation. The agenda for today, we have a couple of things we'll talk about. One, obviously, overview for Regulation F. What is it and what's required? We'll then talk about what those implications are for first-party collections and creditors. Once we've concluded that section, we'll move into vendor management and audits, then future rulemaking pertaining to creditors. So again, questions are welcome throughout the presentation, and I know many of you did submit questions in advance of the presentation today, so we'll be addressing those questions as well. So the first topic is obviously Reg F, and what is Reg F? So Regulation F is part of the debt collection rule from the CFPB. The rule was released originally in two parts in October and December of 2020. The entire rule is effective November 30th. So just 2 short weeks from today is the effective date of Reg F. So part 1 had been focused on communications with the consumer and debt collector and the use of new technology, welcoming in some text messaging, email concepts. Part 2 focused mainly on debt validation notices and credit reporting and the guidance for time-barred debt. And now Regulation F mainly restates the Fair Debt Collection Practices Act, which we've all been living for a long time. And then it has some clarifications. It provides some safe harbors for collection activity, which is welcome. And then it does address additional new technology. So that's basically what Regulation F is. So the first section to that is, obviously it applies to third-party consumer collection. So it's consumer-oriented, not commercial-oriented. Since David, you oversee our consumer collection practices, I'm going to ask you the first question. So to what extent does this regulation apply to collections for commercial business loans?
Well, I appreciate that. I like nice and easy ones to start out with, a nice softball here. And it's a great question to get out of the way immediately, because and hopefully, obviously the answer, we don't see the attendees shrink because they're going to walk away with this. But if your business only deals with true commercial and business loans and accounts, in general, Reg F and the FDCPA do not apply to the collection of your debts.
Excellent. So as a judgment debt purchaser, so if someone's buying debt, do the rights to collect on that judgment that are transferred to that, I'm sorry, if the rights to collect the judgment are transferred to that party, so now they own that debt, does this apply to them, and is this new notice we'll talk about under Reg F applicable?
All right, you went from an easy one to one that's a little bit more technical, and I appreciate that. So first, I'm gonna throw out something, because I'm gonna add a new thing to your acronym dictionary. We've got MVN. You're gonna hear that throughout today. We may say it in full, or we may call it MVN. MVN is the model validation notice. So we're gonna get into much greater detail in the next coming slides here in moments, but I just wanted to throw that out there because I think that's a critical thing that you're gonna hear a lot. We're talking already about FDCPA and Reg F. Again, MVN is going to be out there. So it's taking a step back. Does a judgment debt purchaser need to comply with Reg F or the FDCPA? Again, that is a technical question, and it's technical because you've got the law itself and you've got case law determination. So the definition of a debt collector in case law has indicated that a debt purchaser may be considered a debt collector, especially, and this is where it gets technical, where your principal purpose is to purchase, principal purpose in collecting or purchasing that is to collect debt. So if you are collecting your own purchase judgment, you very well may be deemed a debt collector and will be required to issue and comply with the Reg F and the FDCPA, including issuing the MVN notice. And in any event, you still need to provide the data necessary for your collector if you're dealing with third-party debt collectors in order to collect on that purchase judgment information. So whether you need to worry about it directly as your own entity, or you need to worry about it through your third-party consumer collections collector, it's absolutely required and necessary to follow it.
I think the good point there, David, is the definition of debt collector. So we have the definition of debt collector under FDCPA, but we may also have varied definitions under state law. So just because you are the purchaser of the debt with the rights to collect on any judgment or the claim and standing in the shoes of the original creditor, that may not release you of some of these obligations, depending on looking at the definitions in both federal and state laws. So the next interesting part is, of course, I did mention the effective date of Reg F is November 30th. So in 2 weeks, this is the effective date. So it's not December 1st, it's not November 29th, it's November 30th. So one of the questions that we received was, how as a credit union do you prepare for this effective date? So Beth, I'm gonna toss this one over to you.
Okay. Good morning. So the best way to prepare is to determine ahead of time, prior to November 30th, what itemization date you're going to use. Many of you may have already been contacted by your relationship manager or from our compliance department, reaching out to try and obtain the information from you in regards to what itemization date that you're going to use. So that's the first thing, is making sure that you're prepared, you do know what you're going to use as an itemization date, and that you can provide that data consistently when you're placing business with Weltman.
So what happens if a credit union or another creditor isn't prepared and doesn't have the data necessary by November 30th? I'll throw that up to any of you.
So in our worlds, for electronically loaded clients, it will delay your business being loaded into our system, because certainly we want to make sure that we are sending out the correct information on the model validation notice. So, in order to prevent those delays, the more prepared you are ahead of time, the better it will be. If any of you are electronic loads, you may have already been asked to send a test file. Certainly, we are doing our own internal validation to make sure that our information is correct and that it balances to the information that you have provided us in the placement file. So certainly, those are some of the proactive steps that you can take, providing us a sample file and information ahead of time so that we can make sure that there isn't a long delay.
Okay.
I think the key word to that is delay, right? There will be delay if the information is not complete and there immediately. So, and obviously expect to hear from whether it's us or whoever else you're using to reach out and say, hey, we can't move forward without this information. So let's straighten this out as quickly as possible.
Absolutely. So there'll be basically a big red stop sign. If you don't have the data that we're required to utilize under Reg F, we won't be sending out that model validation notice until we have the proper data. We're protecting you, we're protecting ourselves, and under Reg F, we're protecting the consumer because we don't want to send out a notice that's incomplete or inaccurate. So before we get into the details of the model validation notice and some of the regulation, Jamie, what's one sentence that you would use to sum up Reg F?
I appreciate Sarah asking me this question because she knows that I'm the king of brevity, which is absolutely a lie. One sentence, I think, overwhelming can be, I think, is something that a lot of folks will feel with Regulation F, is that it can be overwhelming. But I think if you want to put a positive spin on it, it's also, I would say, welcome. I think we have to go back to when, in some ways, maybe not other ways, but again, positive spin, let's be positive. We go back to 2010 when Dodd-Frank was passed and the creation of the CFPB and the charge of the CFPB at that time to create rules for debt collection. And many of us in the industry, attorneys and folks alike, have been waiting for those rules for a very long time. I think as we would all agree is, it's a lot easier to play the game when you know the rules versus kind of sitting out there and not knowing what is required, what's not required. You have split decisions in certain circuits of the way certain things are treated. What these rules do provide is a roadmap and guidelines. And I think in many ways that's welcome. So yeah, there's some interesting things that we'll go over, but at the end of the day, we have a roadmap of how to operate within, and also, as you'll hear, to provide safe harbors to us that's very welcome. So that's the positive view, right?
Gotcha. I agree. I think what it does is provide some consistency, right? So the MVN, the notification for all collection outfits, the vendors are all going to be the same. Everyone has to comply with this notification. It does provide a format, which we'll show you in a minute, that the notice has to include in order to take advantage of the safe harbor options and have a safety net, if you will, from any enforcement action from the CFPB or suit by a consumer or their counsel. And it does provide those specific languages that a consumer could then be expecting the same thing and some uniformity for them to receive. So on both sides of the table, I think the intent is to be fair and consistent.
And I would just
go ahead.
I was going to add to that, Sarah. The other thing is, in addition to providing that consistency, it also, I think, helps the industry as a whole. It takes out some bad actors that may be out there, because there is a lot, as you'll hear, there is a lot of work that has to be done to get, and taking in a file now to provide the information with it necessary for an MVN. And so having that infrastructure with whatever vendor you're using is going to be key, because it does take a lot, and not only from us, but because we need to get the information from you as a first party creditor, it's a lot. There is more on you to provide to us. So I think that communication that's going to create is a good thing. We're going to make sure that we've got all of our ducks in a row, so to speak, at the outset.
Okay, so with that, we're going to move over to those first party creditor implications. We're going to actually talk about the model validation notice, what this data is, the itemization date that needs to be provided, and a couple other things that are provided within Reg F. So initially, we're looking at this model validation notice, the MVM. You know, this is the form, and if we go to the next screen, we'll see it, and we'll go back and forth a little bit, but the very next screen shows you what the notice is, and this is a template that the CFPB is requiring be used, and this is going to be the first notice that goes out to consumers. This there are no debts that are grandfathered in. This is every consumer debt that you're collecting as of November 30th must have this information. And I realize it's a little bit small on the screen, but as you're working with us or any of your vendors, you're receiving a sample copy of this directly, and if you haven't received it, you know, we can certainly provide it to you afterwards. So Beth, there was a question about whether this would replace our initial demand letter or modify it in any way. What do you know about that?
So it is going to replace the initial demand letter that we do use today. So if you are a first party and you're placing debt with us, in the go forward as of November 30th, we will be sending the model validation notice, providing we have all the information received from the client.
Excellent. So again, going back to that stop date, if you haven't provided us what we've asked you to provide before November 30th, we will not send the initial notice out, and we will not commence collections. Your accounts will have to be on hold until we have the proper data, proper information needed to proceed. So speaking of the data needed, the data to be provided, one of the items on there is an itemization date, and an itemization date does give you 5 options, 5 things that you can use as a creditor to supply to your vendor. So the itemization date can be the date of last payment. It can be the date of last transaction. It can be the date of your last statement. It can be the date of charge off if you do charge off your accounts. And if applicable, it could be the date of judgment. And not everybody obviously would be placing accounts with an existing judgment. So is it important, Beth, to provide that same data? I mean, does it matter if they pick one or the other for the data being provided?
So it does need to be provided consistently. So if you are making the decision that you are going to provide last statement date as your itemization data, then you would consistently need to provide that with all your account placements. There may be some exceptions to that if you have multiple types of business placed with us. Some clients might have pre-existing judgment programs that they place with us, and they can provide the judgment information. And then they may use the last, statement date or the last payment date for all their other business. So it really, depends on what type of business you're placing. And certainly if you have questions on that, probably best for you to talk to your relationship manager so that we can have a conversation and, kind of give you some, direction on what might be the best thing for you to use.
So if a creditor, first party, is going to place with a vendor, so if somebody's going to place an account with us and they decide they're going to use the date of last statement as their itemization date, does it matter whether they're continuing to run interest or not? Jamie or David, you can chime in. Does it matter if they have interest continuing to accrue on an account?
Yes, it does. So and if you look at the notice itself, there's a box, right? And that box contains the data that we're ultimately looking for. And among that is if there's any adjustment in the balance, positive or negative, increase or decrease, that must be identified within that notice. So if they're selecting, I think you said statement date. If you're selecting that statement date, interest continues to accrue, we need to identify the date, the balance as of that date, and then on the line that is to be for interest, add the interest as of the date that the letter is being sent out.
And what if they're not charging any fees? The next line item is whether there are any fees. What if they don't charge fees? What do they do there?
In the key on the MVN is that if there's nothing being charged, you can't leave it blank. You just put you have to put a figure. So you would put 0, but you don't leave it blank. I think ours will. I'm not sure. Maybe Beth will default to 0 if that information is not provided, but it'll say 0 on there and not a blank. But that's one of the keys from the rules, is that those cannot be blank, because that would be ambiguous.
So if, I'm sorry, yeah, definitely if they are placing information and they leave a data point blank, that will stop the letter process, because we do need the 0. And so if you're placing business and you leave a column blank, it will stop the MVN from going out, and we will be reaching out to you, and hopefully we'll know that ahead of time. But we definitely want confirmation that the blank really is 0 before we just move forward and send out the notice.
So understand, in first party, we can't assume what you're thinking. We can't assume what your business practice is. You have to fill out the information accurately and completely, as well as consistently. So you have to fill out and advise us which date you're going to use as your itemization date. Consistently use that. And if you have to fill out if there's any additional charges, whether it's interest, whether it's fees, whether there's any payments or credits, so that we then have calculated a balance as of the date of our model validation notice, the notice going out. So from a data standpoint, it's extremely important to be consistent. And again, if there are any hiccups, understand and expect that we will stop. Again, the red stop sign will come out, and we'll reach back out to you to make sure that you're confirming that data. We're not going to make an assumption and fill it in for you. Okay, so the next thing that we'll talk about under Reg F is really what are call limitations. What does that mean? And with respect to call limitations, does it also impact who we're allowed to contact? So Jamie, what is a call limitation under Reg F?
So one thing that did come out of the rules is there are now express limitations on how many calls you can make in a certain time period, and how long you have to wait to re-engage a consumer after you've made contact. The rule can be called, the 777 rule, the rule of sevens, but essentially there's 2 parts of it. The first is that when a violation of the rules is presumed if a debt collector contacts a consumer more than 7 times in 7 days. That's the first one. A violation is also presumed if a debt collector communicates or has a conversation with a consumer and then calls that consumer back within 7 days. You have to so essentially you have to wait 7 days to re-engage. There are several exceptions to the rule, and regarding the call limitations, the 7 calls in 7 days. First of all, a misdirected number, a number that's dialed that is actually not the consumers, that again they call it misdirected, that would not be included in that call count. We'll talk here in a little bit about LCMs, or limited content messages, but those are included, and we'll talk about that here in a little bit. But the big one, the big exception to both the 7 and 7 rule and then the contact within 7 days after communication is consent. Is if you can provide consent from the consumer showing that they have consented to you contacting either more than 7 times in 7 days, or that you can call them back within 7 days after communication, that consent is an exception to that rule. I think the other thing that, and so for purposes of sort of what we have to do there, it's important when you're doing your talk offs, when you're thinking about how you communicate going forward, is how do you capture that consent? Because obviously those are pretty bright line rules, and also can be somewhat difficult, right? I think one of the examples out there would be if you're talking to a consumer, you're on the phone, you're having a productive conversation about a resolution, and the call drops. Can you call that person right back? Well, no, you cannot. because that would be contacting them again within 7 days. So kind of wrapping your head around that, and again, getting the consent recorded somewhere, whether in your notes, call recordings, whatever it may be, to be able to re-engage that consumer, I think is key. And I think another thing to think about is when you have multiple co-liable parties or you have multiple debts. The rules talk about particular debt, particular person, which is, you know, here at Weltman, we may have 3 or 4 different files for the same consumer, with 3 or 4 different creditors that we're servicing. And so the question is, are we limited to 7 calls in 7 days as it pertains to all those debts? And the answer is no. The rules say it's the particular debt. So on each one of those debts, we could conceivably contact that person 7 times in 7 days on each one of those debts, as long as we have a way of showing that it's for each one of those particular debts. Same goes with persons. If you have I'll just take an example, like an auto loan, where you typically have a co-signer, and you have two different debtors in that situation. Are you limited to 7 calls in 7 days for each of those persons? Well, no, it goes to each, or for each of those persons, yes, I'm sorry, not in total. So I think the key there is understanding particular debt, particular person. The other thing is, what about multiple phone numbers? What if you have someone who has 3 or 4 different phone numbers? Can you call each one of those numbers 7 times in 7 days? No, you cannot, because again, it deals with the person and the debt, not how many phone numbers. So if you've got a work number, a home number, and a cell phone number, you're going to want to prioritize what those numbers are and which ones you're going to want to attempt, because each time you call any of those numbers, it's going to go into the call count. So that's important to think about.
So one of the questions we received was, you know, is the first party, or maybe are we as the vendor, allowed to contact a personal reference that has been provided by the consumer to the creditor at the time that they were making the loan? So sometimes on a credit application, there may be 2 or 3 references listed. What's the rule, David, with respect to contacting that third party?
So, and again, this is going to get a little technical because we talked a little bit earlier about the definition of a debt collector. If the first party who's asking that is not a debt collector as defined in the FDCPA or Reg F, then that rule doesn't apply to them. And you know, they've obviously got other rules they need to follow, and maybe consider things like UDAP. You know, and I'll talk maybe a little more about UDAP in a little bit here, but what that is. But as far as the direct, the rule itself, FDCPA and the rule, a first party doesn't necessarily have to consider that. However, if you are a debt collector, then you absolutely need to be concerned about third-party disclosures and what information you are disclosing to the party who is not the consumer, and whether or not you have permission to talk to that person. So, and then we as a collector are only able to use that information to the extent that we need it for location purposes. So if we need to locate someone, that reference is a good point of contact for us potentially to at least reach out to try to locate the debtor. But we cannot speak to them about anything about the debt itself without any sort of approval from the consumer.
Okay. Before we go to the limited content messages, there were 2 questions that came in regarding, again, the MVN, our model, the validation notice. So one is, prior to sending that, does the creditor, first party, need to provide a notice to their customer or member of the dollar amount to which we're going to have on that notification before they've assigned it to us? So do we have any takers there?
If I understand the question, if the question is, does the creditor need to provide a separate notice prior to the MVN going out? I am unaware of any requirement of a notice. Now, again, you do have notices that are required in secured collateral, secure transaction situations where you're sending out deficiency notices, things like that. But if it's simply sending out a notice prior to sending it to Weltman to begin the collection process, no, there would be no requirement to send that out. And in a lot of ways, I would say that I would discourage such a notice at this point, because the model validation notice, as you can see, provides a lot of information, and that information will come from one source with completed. And I think that coming in that one way, that one voice, with all the fees, interest that may be accruing on there, broken out and itemized, I think would be the better approach.
I think some creditors do like to use, Jamie, a final demand letter, or if they're doing a charge off of their account, they do like to send their own letter. So is this basically saying, from what I'm hearing you say, Reg F doesn't apply to them for that purpose? So if they currently send a charge off letter or a final demand saying, hey, if you don't respond by this point, we are referring this out for third party, or something to that effect, they're still okay doing that, but they're not required.
Of course, you are not required to do it, and clearly there is benefit to sending out notice or making attempts to contact your consumer and resolve something before sending it for collections. And if that is a written notice, demand, however you want to characterize it, I think that's fine. I think that to the point of Reg F, it's not required, and the model validation notice will be what is required of Reg F, and that is what's going to ultimately be the defining of the process that needs to be followed from our standpoint, from Weltman's standpoint.
Okay. And another question was, can this notification requirement under Reg F be satisfied with just the creditor's most recent periodic statement? And David, the answer would be?
So if you're asking if the MVM can be satisfied, no. The MVM is satisfied only by the MVN itself. So that notice needs to be sent out. If you're providing that to us or to whoever that last statement, that's perhaps the statement date we will use for the balance calculation. But the notice itself is very detailed and very exact, and the wording is very important. It cannot change from that. I mean, there's limited deviation from what's here that can be made, and any deviation takes you outside of the safe harbor with the CFPB.
I think that's the important part. The Reg F is providing safe harbors, and those safe harbors are to protect your vendor and you from any claims, from any enforcement actions by the CFPB, as well as any claims by the Consumer or Counsel saying that you violated their rights under Fair Debt Collection Practices Act, that you did any, harassment or abusive behavior. If you comply with and follow this model in your validation notices that you're sending, you have that protection. Now, obviously, that only applies to the notice. So if you send the notice out and it's appropriately following this guide, but you make 9 calls in 7 days, you can still be found to have potentially violated fair debt by some sort of abusive or harassing behavior. So this is, again, one component of Reg F, but then we also do have, as Jamie talked about for a little bit, the call limitations that have now been set forth in Reg F, and then the little bit of a give, I would say, for creditors and third party is that they did include, though, limited content messages that are outside of that 777 rule. So Jamie, do you want to talk about what a limited content message is and how that may perhaps help third party collections?
Well, a limited content message is essentially a voicemail. It's a voicemail that you are leaving to a consumer that you're attempting to communicate with. It's an attempt to communicate. It's not an actual contact. An actual communication. And that's important from what we talked about earlier on the rule of sevens, is that a limited content message is included in the call count because it's an attempt to communicate. So there is required content and there's optional content when it comes to an LCM. And that, again, is what the kind of message that you are leaving when you attempt to contact a consumer. And so here's sort of the required content, what must be in a limited content message. Number one, the business name of the debt collector must be left, so long as that name does not indicate that it's from a collections company. So by leaving, for example, I'm Jamie Hart from Weltman, that doesn't say or imply that you're calling from a collection agency. Now, if your vendor is called Acme Collection Agency, and you say I'm Jamie Hart from Acme Collection Agency, that could be a problem. So you'd have to maybe leave it at Acme or something to that effect. But number one, you've got to provide the business name. You've got to provide the name. A request to actually reply, to respond to the message. The name of an actual person that the consumer can contact to discuss the matter with, and then a phone number for that person, or that they can reach someone. And that is what is required to be left in an LCM. Things that absolutely cannot be included. Number one, the consumer's name. You cannot leave the consumer's name in an LCM. Two, you cannot leave ask or leave a reference number or an account number. Like a lot of folks will make a call and say, please call me back, and when you call me back, please reference my account number, da 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 da. You cannot do that in an LCM. There are other things you can include. They're optional. But for example, saying hi, like a salutation of some point, leaving the date and time of your message, stating that either there's a person that can call, or there are other people available to take your call, and it's okay if you talk to other people if you call this number. Those are, and then also providing suggested dates or times that would be beneficial for the person to call back to reach someone. Those are okay. But the key there is when you leave a limited contact message, the business name, the name of someone they can actually reach, a request that they reply, and then finally a phone number, which can be very simple, right? It's a very simple message. Hi, my name is Jamie Hart from Weltman, Weinberg, and Reese. Please call me back at, and then provide the number. That's fine. I've left my name, my business, name of my business. I've left a phone number they can reach me at. Now there are others. For example, maybe a more robust example would be, hi, my name is Jamie Hart calling from Weltman. It's 4:15 p.m. on Wednesday. Please contact me or any of our representatives at 1-800-555-555 and today until 6 p.m. Eastern, or you can contact me between 8 and 5 o'clock any day, rest of the day this week. Again, that's a lot more in that message, but it's okay because, again, haven't used the consumer's name, haven't left a reference number. I've requested my callback. I've given my name, a number, and who I'm calling with.
So there was one question that came in, and I think they were still referring back to the MVN. So I apologize, we're toggling a little bit, but the question was, are they correct that the name and address is required in both sections? So if we look back at the model validation notice, I believe what they're talking about is in the upper part of the letter and the bottom part of the letter. And yes, the model validation notice does provide the name and address in both sections. So they're going to have who it's addressed to and your, like, for example, it says on the model notice, North Shore Group, and then at the bottom it's really like a tear off, hence why they have the scissors pictured there, but for the person to potentially tear that off and remit that in an envelope to send back to you, so that'll have both the consumer's name and information as well as the remitter, the third-party collection agency's name and address. So it is required in both sections. Another question that came in is, what if you stop charging interest at the date of charge off and use the date of charge off? And I think, David, you referenced a little bit of that earlier. So is it okay for someone to stop continuing with interest accrual?
Absolutely. If that is your policy to stop interest accrual, or perhaps the line of business you have requires that as well, or doesn't allow for it, then yeah, you can absolutely stop interest accrual. And frankly, it makes it an easy calculation. You're using the charge off date as your itemization date and your balance at charge off, and then you're going to give us, if it's coming to us, a 0 in the interest accrual section.
Right.
Excellent.
The important thing is that, the data is provided, even if you're not charging interest or even post-charge-off fees. It's important that you still give us a 0, because if you give us a blank, it's going to fail our process for the MATA validation notice.
Okay, so next we'll move on to vendor management. So with vendor management, we're going to talk about work standards, expectations, record retention, and audits and oversight. So I know there was a question or two that had popped in while we're doing the presentation in a few of those categories. So first off, David, I'm going to ask you to talk a little bit about work standards, and these are really what the client may provide to us as we're working their accounts, and if they don't, we do have internally our own set of work standards.
Yeah, so we've talked a lot about, and I understand a lot of people on this phone call work for first parties and perhaps aren't directly impacted by the rules as we've kind of outlined here, except for what we've really highlighted so far is the data requirements that we need for this MVN. So you might think, all right, how else does this apply? Why else should I care about what these people from Welton are telling you today? Well, I can tell you that your work statements and work standards and expectations are impacted, and if you've delivered any of those to us or anyone else you're using, you're going to want to take a look at what Reg F says your collector is allowed to do and what you have historically prescribed them to do. And for the reasons outlined in the last few minutes, and maybe for the rest of this session, those work standards and expectations will need to change. And again, the more detail that you have maybe been historically with either Weltman or someone else, the more we're going to have to take a look at that. And some of the things you've got to maybe start to think about is, again, we've talked nonstop about data so far, and the delays that can cause. So data is the critical piece, is step one. We've also talked about some timing issues. Obviously, faulty data is going to delay collections. There's also another piece that's in this MVN that has not historically been there. Historically, when you send your initial demand letter, you've got a 30-day window, technically, for the validation period to run. And the validation period is the time for which the consumer has to dispute the debt and ask for verification. Well, according to the MVN and Reg F, there still is a 30-day period. However, they've also baked in some additional time to allow for, especially if you're using mail, for mail to take place, and they've incorporated a 5-day mail rule. So right off the bat, you're at 35 days. In addition to that, they've prescribed that the company issuing that MVN needs to state specifically a hard and fast date when that validation period will end. As a result of that, we're going to have to select a date, and we're definitely going to select a date that is at least 35 days from the date that's going out, and probably build in some additional time, because you think of holidays and weekends and some additional delays like mail being picked up. If you approve a letter at the end of the day, it's probably not going to go in today's mail, even though it's dated for today. So you're already seeing that you might have to add additional days. So what was historically a 30-day period has now expanded to at least a 35 and potentially up to a 45-day period. So you're already looking at, again, some additional delays in the process that we've historically had. Just a side comment, validation, again, although we're prescribing, the law prescribes a specific date, Weltman and many others in the industry typically accept validation requests at any point after that time as well. So just wanted to throw that out there. In addition, we've had clients who have prescribed specific language that needs to go into a demand letter. And as we've discussed, that MVN is the safe harbor, that we cannot deviate from the language that's in there. And there is some limited ability to make some changes, but if you go far beyond what's prescribed in the rule, you're outside of safe harbor. So very simply, that MVN is going to be what is sent, and prescribed language will probably not be accepted at that point. Jamie's talked about the 777 rule, the call frequency. If you have historically dictated a certain number of calls take place, now that dictate must be within that 777 rule. Obviously, you can be more restrictive, that's not an issue, and that's obviously something you'll talk about. But and again, we've had some clients who have required specific language in any messaging that we left. Well, Jamie's gone through what the limited content message is in the safe harbor. That is the language going forward. You're going to need to forget about some other things that you've prescribed in the past. And ultimately, the third-party debt collector is going to do whatever it can to fall within those safe harbors. And so our expectation is you're going to have to adjust your standards and expectations going forward accordingly. It's just the way that the rule is written and the way that it needs to be followed.
So with respect to the work standards, again, if clients have their own work standards or they're relying on our firm for our traditional work standards, what you're going to see is there may be some edits or modifications to those to incorporate, again, what the rule is requiring for how many days the consumer has within which to respond. I'm sure we've all noticed that the U.S. Postal Service, God love them, isn't exactly delivering as swiftly as they used to. So you may see in those conversations a decision to maybe give 40 days so that you're covering the 30-day notice, the 5-day mail rule, and a little bit of push for slow mail to make sure that, again, your next step being taken on an account or your next letter isn't overshadowing this validation notice and losing that safe harbor protection. There was a question if we would be providing an updated transmittal, and the answer is yes. We have issued out to our clients, depending on if they place with us electronically through a modified electronic placement or manually, some modified transmittal forms and templates. If you haven't received those, please reach out to us and understand that if your next placement with us isn't in the new format, we'll reach back out to you, of course, and make sure that you do have the forms and the materials necessary so that we are receiving the appropriate data. So there's going to be more conversations over the next month or so, even probably into next year, as we continue to roll out these changes and make sure that our clients understand what's required of them so that we can actually work those accounts. So definitely there's going to be just, I think, a little patience and understanding on both sides so that we can work with you to best capture the required data, and that we can, again, take advantage of the safe harbors that are provided in Reg F. There was another question, David, that was asked, what is the impact on lenders or creditors in early to late stage delinquencies as far as a contact strategy? So David or Jamie, do you want to talk about what some of those expectations are or what they can possibly change?
Well, I think is the contact strategy here. I think we talked a little bit earlier about, from as you can see from what we talked about with the 7 and 7 or Rule 7s and things, there are new rules on us that we have to comply with, and so the expectations have to understand that these are hard and fast rules. As David said, standards have to change, but also a lot of our clients I know have standards that are actually a lot less than those rules. So Weltman is very, and I'm sure your other vendors too are familiar with these. We're able to, we understand the limitations and how we have to comply. I think understanding when you're talking about delinquency and as a lender and coming up on decisions that have to be made, you're going to have to look now and see when you go to refer a file refer a matter to counsel, whatever it may be. There are now certain things that are going to be required of you that you have to provide to us. We've talked a lot about that today, about just the vast amount of information now that has to be sent to us to even take in that file and to take step one. So understanding that, I think working with your consumers and getting on getting some sort of forbearance if you can, but how that may impact your balance, and how at some point you're going to have to be able, when you send these things to us, to document that, to provide the documentation that supports your balance, because we can't move forward without it. So I think just keeping that in mind, that it's not just simply providing a transmittal, a simple transmittal that maybe you have in the past couple of years, and then we send out a demand and hopefully get some contact. there's a lot more structure to it now and a lot more information that's going to be necessary.
So there was a question about, again, piggybacking on their prior question, if they don't fall into the definition of creditor because they are an assignee of the original creditor, does that then put them subject to Reg F? And I think, David, you answered that earlier, that in essence does, right? But they really should be looking to also possible state regulations beyond just this federal Reg F, right?
Yes, correct. I mean, if you're falling within, as an assignee, if you're falling within that debt collector, whether it's in the federal side or state requirements, then unfortunately you're absolutely going to have to take that into consideration. And you know what may have been done through what looks more like a formal letter, delinquency letter or something like that, is going to look different because now you've got the model validation notice you're going to have to handle here to address.
Gotcha. There was a question just now posed. What should be included, if anything, on the reverse side of the model validation notice? Can it be blank in any case? And if so, can the wording be removed? Can this wording be removed from the model validation notice? What I would say is, and I'll let you guys chime in, follow the model validation notice with your vendors to a T. You can change it if you want, and there are some suggested changes, even alternative language. If you change it, though, you risk losing the safe harbor. So the idea is, as set forth, there is nothing on the reverse side. You can put something on the reverse side, but to the extent you put additional content in your validation notification, you may lose the safe harbor. So I don't know, Jamie or David, do you want to chime in on that?
Yeah, one other thing that I know we've had to think about is, you know, again, we talked about state laws, right? So we operate in states that have specific requirements and additional language that has historically needed to go on our demand letters, and so those state laws haven't changed, so there needs to be a place for that. And again, you know, if the letter's going into a state that doesn't require any sort of notice like that, then it should be blank, unless, you know, we can have some conversation on what potentially to add there, but it must be within, as we described, that safe harbor. Those notices that states require, though, that's the location for that, because there is no other location. So for, you know, most generally in states that require specific language, that's where those notices are gonna fall.
Yeah, I would just say that if the teacher gives you the answers to the test, you should probably take those answers and go with it. So if this, I tell this to my my 7-year-old all the time. But you know, if the CFPB is giving you the map of how to go, then I don't think that you should deviate. And anytime, I think this goes back actually to you know, many years ago when, you know, a lot of folks would deviate from a simple demand letter. And I think if you talk to any lawyer out there who's dealt with FDCPA claims relating to demand letters, they'll tell you sometimes it's the deviations that get you in trouble. The trying to make it, you know, more is, you know, trying to, you know, fluff it up, make it look a little better, make it sound a little bit, you know, whatever. So
The old adage of less is more is your answer, Jamie?
Well, I would say less is more. I would say less is more, but as you look at the model validation notice, it's not less. But I also do think, and I think I saw this in the rule somewhere. There is something in the rules that allow for a model validation note to have a second page. I would say putting stuff on the back of the model validation notice would be problematic, because one of the stated rules is it needs to be clear and conspicuous. Putting something on the back of a page may not be so clear and conspicuous depending on who's receiving that. But I do know that the rules do provide that if you need extra room to produce the content necessary to comply with the MVN, I think you can use a second page. So if you're looking at that, I would go with the 2-page avenue.
If you were choosing to put something on the reverse side, you cannot take up the space where the bottom part of the tier sheet is. And the idea and the discussion or commentary behind that is that if the person is tearing that off and mailing it back to you, the part that they're retaining must have all the information on it. So if you put something on the back and it carries down into that bottom third of the letter, and that's one part of the tear sheet, you're now basically losing your safe harbor. You may not necessarily get an enforcement action against you or a suit, but you may. So again, losing the safe harbor is huge. Jamie, there's one person that did ask if you could elaborate on leaving the limited content message. If the limited content message doesn't have the consumer's name and somebody calls back, but it doesn't happen to be the consumer, what do you do?
It's a good question. I've had this question before, and when that person calls back in, first of all, that's it. Now you're in a communication with, and you have to follow your guidelines as to verify that person's identity, right? So I think as long as you're following the guidelines that you're verifying personal identifying information, last four of the social, things like that, and you get that person on the phone, then you're able to communicate with them and go through with the talk off. But yes, not leaving a name or a reference number. I think, this is a very bland message that you're leaving. And to the extent that if a third party were to overhear this message, I think that the key there is that they would not know what this message is for. And I think that's the intent. I think the intent is that, you're contacting someone and you're asking them to call you back. Again, you have to have a request for them to call you back. And so it's on, I guess at that point, the obligation to respond passes to the consumer now that you've left this content message. And when that person calls back, and let's say it's not the right person, at that point you can figure out who called, and then that would be a misdirected number of some sort. You take that out of your system, and again, that prior call would not have counted in the call count. But yes, you gotta do that work.
Part of the confusion would be if third party calls me and says, hey, I'm returning a phone call, how do I know what account that's relating to? And so I think one of the critical points in your data system is the ability to, first you're going to ask them their name and search by their name. If nothing comes up, you're thinking, okay, I probably don't have the right party here. You may ask them, what phone number was the message left on? And hopefully then you need to have a system that allows you to search by phone number. If that phone number matches up with a consumer account, but you're not talking to the consumer, you're going to need to then update your records that that's not a good number for the consumer, and you're going to need to end the call. You obviously can't disclose information to the third party, but you need to then realize the number you called did not match up with your consumer. Update your records so that you don't continue to call the wrong party. So there's another question. Can you ask the consumer to have their account information handy when returning the call? I think that would take it outside of a limited content message, right, Jamie?
I mean, I would agree. I think I mean, again, they give you the answers to the test. Do the answers to the test. Yeah, the LCM, I mean, there's optional and required content, and the optional content, I think you're getting dangerously close to putting a burden on the consumer that the CFPB does not want you to put on that consumer. When they call you back, at that point, I think you can obviously request that information and go through from there. But leaving that on a message would expose liability.
Okay. I know we're running tight on time and we have two more things to talk about. So the record retention is addressed in the Reg F. So Beth, there's a 3-year rule on keeping records. Does that rule cover both first and third parties?
Yes, it does. And additionally, there are some state laws that may require that you retain records for a longer period of time. So you want to take that into consideration as well when you're, looking at your retention policy.
So I think with a lot of records now being stored electronically and backup of electronic records, it's not as onerous as it used to be when we didn't have that ability. Our firm, for example, stores records longer than 3 years. So make sure that obviously you're in compliance with that, and understand that while this is a federal regulation, there may be state laws that have other rules. I think there are some states that require up to 10 years of record retention. So the last section is audits and oversight. I know, David, you were talking a little bit about that with some work standards, but do you want to add a little bit more there?
Yeah, I can add a little bit, or I can add just a little bit. So it's I think just in summary and kind of the work statements, your audits and oversight that you have, incorporate the Reg F requirements in your audit and your due diligence oversight. So if you have, you know, those requirements that are in Reg F incorporated into your audit, then that's what needs to be added. So that can be as short as that. I can go into detail if there are any questions.
There's a question about recording of phone calls, and some states require two-party consent. When you're trying to keep track of, for example, the 777 calls and the limited content messages, I don't think that what we're stating, and I don't think what the regulation states, is that you're recording the phone call, but you have to have records that record how many calls you made in that period. So did you have a limited content call go out? Did you speak to the consumer in a full conversation? Those are the things that you have to somehow track in your system so that you're not falling into the presumption of violating Reg F and FDCPA, not necessarily recording every call or violating a state law that may require mutual consent. Do you guys want to talk about that at all?
Yeah, I would add that virtually all of our clients do require call recordings. So we do comply with, you know, in whatever state we're calling, the requirements of that. We ask permission or we indicate that the call may be recorded and will be recorded. But what I would say is that call recording, those call recordings are critical because, you know, if we're looking at deviating from the 777, we're looking, did you get verification or permission? Well, you better, if you got that, you know, in an audio call, then you better have the recording of that clearly indicates that you were given permission to either call with, you know, another time within 7 days or to call back, you know, within that 7-day period. So that's critical.
And I think if you're using that call to obtain consent or permission from a consumer to do something, use a phone number, cell phone, use an email, or call them back in the event the call is dropped more than 7 times in 7 days for the 7-7 rule. You could also, in that same conversation, obtain their consent to record that so that you're indicating, you know, is it okay that I record you consenting to these things and that we're going to store that. So again, it's a one-off, and I don't want to take up the whole remaining time answering the question. We can certainly follow up with the person because it's a pretty long question that they typed in there. And if there are any questions on here that we haven't gotten to, I know there's a few more that have been flowing in the last 5 to 10 minutes. We will address your questions, the answers to your questions directly to anybody that's posted if we haven't covered it yet. So we are at 12:02. I believe our program is supposed to end at 12, so we're 2 minutes over. I do appreciate everyone that has participated in our session today. Again, you should be receiving a short survey that will pop up on your screen when the webinar ends officially. So we'd like you to please take the time to share your feedback. Let us know of any other topics you'd like us to cover in the future. And understand we also do have a complimentary library of at least 20 webinars that you could view and access. So this one was recorded, it will be available, but we do have other ones that address bankruptcy, probate, real estate, other things in our library. So feel free to access our library at your leisure. Thank you again for attending this, and have a great rest of your day.